Hi, I'm going to talk today about one of the most frustrating aspects of representing military personnel going through the discipline system. And that frustrating aspect is the gap that exists between the conclusion of an investigation and the start of a prosecution. In the service law, there is frequently a gap of months or longer between the end of an investigation by, for example, the Royal Military Police and the start of a prosecution in the military courts. I say prosecution, it could be other outcomes such as AG 67 or CO summary hearing, but I'm going to say prosecution for just ease of reference. Likewise, I'm going to use military police, but it could equally be the MOD police, it could be the RAF police. So what sometimes happens is an individual is investigated by the Royal Military Police. That investigation may span weeks or months itself, and it may take in several interviews. At the conclusion of those interviews, one of two things always happens. Either the military police officer will say that they or another service person may wish to speak to the suspect at a future date, or they will refer the matter for prosecution, either with the CO or to the Service Prosecuting Authority. But then what happens frequently is a big long gap between the end of the investigation and the start of any proceedings. And this contrasts markedly with the civilian police approach. The civilian police, if an individual is interviewed under caution, at the conclusion of that process, if they are charged at the police station, they're either taken to court that day or the next day, or they're given a bail date to present themselves at the magistrate's court. Sometimes they will be given a letter in the post called a requisition, requiring them to attend court, but that will be within 6 months. In the military system, that doesn't always work, and it can take a lot longer. So I'm sometimes asked, well, what can I do? What can I do with the time that is available to help me if the matter goes forwards? And sometimes the answer is nothing. Sometimes the only thing that is possible to say to an individual is be patient, just wait. Sometimes that's all that can be said, and sometimes that's all that can be done. But sometimes there are things that can be undertaken during that time in order to prepare the best defence for a court-martial. Some of these things, of course, should have been done by the military police in the interview, in the investigation, and put to the suspect in interview under caution, but sometimes for various reasons that doesn't happen. So what examples am I talking about? Well, CCTV. That should usually be investigated by the Royal Military Police as part of the investigation stage, but for various reasons sometimes that doesn't happen. So it might be possible to check whether there's any CCTV, see if shops have CCTV, see if the council, the local town council, whatever, have CCTV, see if individuals have CCTV. Sometimes CCTV is attached to individual homes, sometimes it's attached to churches, public buildings, all that sort of thing. Equally, dash cams. A number of cars now come equipped with dash cams. It may be that the dash cam footage may assist in the defence, so it's important to try and get hold of that. It's particularly important with CCTV and dash cams because frequently, after a few days, the footage might be deleted and then it's no longer available. So if it's important, if it needs to be gathered, it needs to be done quickly. Other examples, for example, if an individual is accused of fraud, if they're accused of claiming for monies received that they haven't spent, it might be that they say, well, I did spend the money, but I don't have a receipt, or it was spent for in cash, in which case it might be necessary to contact the shops concerned or see if there's cash registers or receipts can be obtained. That can be quite useful. Equally, physical evidence. For example, if an individual is accused of having had a fight at a nightclub in a night out and says, I was wearing a red shirt, and the police say that the individual thereafter is wearing a blue shirt. If you physically have the red shirt, retain it and keep hold of it, don't wash it, don't do anything like that, just retain it in its current form. Maybe it smells of cigarette smoke or something similar, maybe it's been ripped. So retain that physical evidence. Other examples that may come along: shoes, treads on shoes. If it's material relating to a footprint, for example, if the evidence relates to a footprint, retain the shoe before it's worn or before it's thrown away. Likewise with car treads, retain the car tyre before it's driven over thousands of miles and the tread changes. Sometimes, for example, if it's a blood case, it might be necessary to retain a sample of blood, or if it's a drugs case, likewise, or hair samples or matters of that nature. It's important to try and retain that material. Of course, as I've already said, much of that material should have already been retained or kept as part of the investigation, but not always. Another important example: witness statements. If there are defence witnesses, they will need to be spoken to. They will need to have a statement taken from them. Of course, that serves a number of purposes. One, it means that you're being proactive in preparing for the case. Two, it means they are then your witnesses, so you've taken a statement from them and they're your witnesses to be used at any court-martial. And the sooner the statement is taken, particularly for example if it's a video statement, it will help, the sooner it's taken, help the individual to retain it in their memory. If you try to ask for it months afterwards, it may be that the person doesn't remember the incident as well as if it's taken closer to the alleged offence. So those are some examples of matters that can be undertaken in the period, in the gap between the conclusion of an investigation and the start of any prosecution.